Honorable Court of Appeals of Tennessee is in session.
Good afternoon. On behalf of Judge McBrayer and Judge Stafford, we welcome you to the Court of Appeals. This hearing will take place just like it would have had we've been together in a courtroom. So it shouldn't be anything unusual to you. If there's any technical problems, we'll stop and get them corrected and go on. We'll be all right with that. And if there's no announcements or anything, seeing none, Ms. Dempsey, would you please call the case?
Home Service Oil Company versus Thomas Baker.
And is the appellant ready, Mr. Dixon?
Yes, Your Honor, I'm ready.
All right, you may begin.
Thank you, Your Honor. Again, Briggs Dixon on behalf of Home Service Oil Company, the appellant. The trial court in this case found that HSOC should be stopped from seeking the entire amount of their judgment against Mr. Baker based on an erroneous court filing from 2013 by HSOC's former attorneys, which incorrectly listed the amount due. Now, I can go through some of the factual circumstances, but there are
incorrectly listed the amount due. Was that some sort of execution? What was the actual court paper that had the incorrect information on the judgment amount?
Now, I can't speak to why they put the incorrect judgment amount. That was a different attorney.
I'm talking about what the nature of the pleading was that was filed with the court. And then
yes. Let me explain a little bit about the factual circumstances, which I think is necessary to answer your question. So they obtained a judgment against Mr. Baker that was for approximately $18,000 and pre and post judgment interest. But Mr. Baker had not paid. So what they did is they found a rental property that Mr. Baker owned, and they had an order for the tenant to direct money he was going to pay for rent to HSOC in satisfaction of the debt instead of that rent money going directly to Mr. Baker. So effectively a lien. What happened was after so many months, the tenant stopped paying. So HSOC filed a motion to show cause in the court and to attempt to figure out why they were no longer receiving these rental payments. And in that motion, they put the amount due, which they incorrectly listed as approximately $4,000. Now, so I hope that answers your question. This was a separate pleading.
And is this motion to show causes in the record?
Yes. I don't have it off the top of my head. I can get it for you at my rebuttal time.
That's all right.
Okay. But
let me follow up on that, because after this incorrect amount, as you term it, was shown, there was some theoretical or purported settlement reached. What is in the record regarding this settlement?
So this is a point of contention among the parties, but there was no settlement of the debt. What happened was Mr. Evans, who is the tenant that I'm referring to when I speak about Mr. Baker's tenant, Mr. Evans is the one who was directing his rent payments to HSOC. What ultimately happened was Mr. Evans sought to purchase Mr. Baker's rental property that he was living in at the time. So what HSOC did is they said, we'll release this lien and let you buy this property rather than us continuing to have our ability to correct rental payments from it. We'll release it for $3,500. Again, and the Mr. Baker makes contentions that this was a settlement. Note that Mr. Baker never directly contacted HSOC about this purported settlement of his entire debt. He alleges that he told his tenant to go offer $3,500 to HSOC to relieve the debt, but that's false. The $3,500 was merely HSOC giving up its rights to continue to enforce a lien on the property to basically take away any encumbrances and let Mr. Evans, a third party who didn't owe any debt to HSOC, purchase that property. And from there, HSOC would have to be left to recourse against Mr. Baker via some other means. Now,
Okay,
Was
here's
that-
here's
was
the
that
part.
Oh, excuse me, go ahead.
Well, here's the part that doesn't make sense to me. So Mr. Evans says, I want to get a release from this lien because I'm interested in purchasing Mr. Baker's property. No,
not technically, and this may be the lien was on the property effectively as owned by Mr. Baker. Okay, so Mr. Baker, if he sold it, my understanding is there would be some issues because we held this lien on any rental payments coming from that property would have to be directed to HSOC. Just to avoid any kind of, for lack of a better word, gumming up this transaction, he could pay $3,500, Mr. Evans, as a part of that transaction, and get that lien completely released so that he could buy the property himself.
well, I mean, that's the part that's confused me. Your client has this big judgment and Mr. Evans wants to buy it from Mr. Baker. Why wouldn't your client say, wait a minute, just pay me what you would pay Mr. Baker for the property and that'll take care of it?
That's certainly could have happened, and that was a time that I wasn't involved and our firm wasn't involved, so I can't speak to why they didn't come up with that solution. But what I do know is that shortly after this transaction took place, Mr. Baker basically fell off the face of the earth, and they'd run skip traces and couldn't find him for so many years. So I don't know what the status is of anything that happened between Mr. Evans and Mr. Baker at this point in time. But
Let me follow up on what Judge McBrayer asked you.
sure.
Did the gentleman subsequently buy that property?
My understanding is that he did buy the property, but I actually am not completely sure, Your Honor. I'm happy to find that out for you and submit any additional
That's
information. Okay.
And was this what you've just recited to us? Was that the proof, or was that the position of your client that was presented to the trial court?
Yes, but I'll say that it's a little bit of a side issue on this appeal. Okay, and if I can, I want to address really the primary focus of the appeal today, and that is this estoppel argument. Number one, the court, in issuing its order in this case, it applied the legal standard for estoppel based on the case Cracker Barrel v. Epperson that was cited by Mr. Baker. While the court correctly applied what is contained in that Cracker Barrel case, unfortunately, that Cracker Barrel case does not list all of the elements that one must meet to assert an estoppel defense. So first, there are 3 elements that must be met that pertain to a party against whom estoppel is being asserted. That would be HSOC, and that's what the court applied. That is conduct which amounts to a false representation, intent that representation be acted upon, and knowledge of the real facts. The court said that Mr. Baker could prove those. The problem is the court stopped its inquiry there. If you look to the case even citing that the Cracker Barrel case cites, which is Warren v. Sanderson, citation is 954 Southwest 2D 742, it notes that there are also elements that must be met with respect to the party asserting estoppel, meaning Mr. Baker. And those elements are primarily lack of knowledge and the means of knowledge of the truth as to the facts in question. The other 2 are reliance upon the conduct of the party estopped, and action based thereon is of such a character to change the position prejudicially. But the focus here is whether Mr. Baker can prove that he lacked knowledge in the means or the means of knowledge of the truth as to the facts in question. So to apply that standard to the facts of this case, a standard the trial court did not apply, the trial court should have said, can Mr. Baker prove to this court that he did not know the true amount of his debt, and that he cannot prove that can he prove that he did not have the means to know the truth? That was the focus of the court's, that's the focus of this appeal, and something that the trial court didn't consider. Now, I want to go back just briefly to the Cracker Barrel case. In that Cracker Barrel case, which the trial court relied upon and which Mr. Baker argued, the Tennessee Supreme Court found that estoppel did not apply. It looked at the elements applicable to the party against whom estoppel is asserted and said that plaintiff can't meet these arguments, or that defendant, excuse me, can't meet the arguments. So there's no reason to go and look at these additional elements. So we would respectfully do not agree that Mr. Baker can even meet those elements pertaining to HSOC, but it's indisputable that the trial court did not consider the requisite elements for estoppel set out in well-established Tennessee law that apply to Mr. Baker himself. And one more brief point I want to note is this is not harmless error, the fact that the trial court didn't specifically mention these. Primarily, the record's devoid of proof on this threshold element that Mr. Baker did not know the truth of his debt or did not have the means to obtain the knowledge of his true remaining debt. And HSOC would submit that it has to be a rare case, much less someone like Mr. Baker, who's a certified public accountant with 30 years of experience, could lack the opportunity to know the true amount of a debt that they negotiated and owe. Now, if they don't know the true amount of a debt at a particular point in time, that's one thing, but they would still have the means to know. And Mr. Baker himself testified that was the case here. He testified that he had been a CPA and businessman for 30 years. He testified that he was familiar with amortization schedules and fully adept at computing interest on things such as judgments. And he didn't dispute, this is a key, he didn't dispute that he received via personal service a citation to judgment debtors to appear for examination on November 13th of 2013 that showed the full amount due as $31,205.11. This was less than 1 year before that erroneous pleading that listed the incorrect $4,000 amount. Now, he also, importantly, Mr. Baker admits that between receiving that citation showing the $31,000 debt due, that between then and October 2nd of 2014, only $14,000 had been paid on his behalf on the judgment. So he knew, or at least had the opportunity to know, that $17,000 was still owed when that erroneous pleading was filed on October 2nd, 2014. I'm running out of time.
And,
I don't want to
just
go
the
over.
only payments that were made on the judgment were made as a result of this lien, or I would call it a garnishment on Mr. Evans' rental payments.
Correct.
Yeah, I'm okay.
So I'll reserve the rest for rebuttal, seeing as I'm out of time currently.
All right, thank you, Mr. Dixon. Mr. Claybo, your turn.
Yes, Your Honor. May it please the court. My name is Jacob Claybo of the Nashville Bar, and I represent the appellee in today's case, Mr. Thomas Baker. Mr. Baker's position on this appeal is a pretty simple one. He believes the trial court did not err in finding that equitable estoppel bars Home Service Oil from establishing the approximately $30,000 debt that they're seeking in this case, judgment that they're seeking in this case. On the oral argument side of this, I want to talk about three things, and I'm going to go kind of in reverse order as they're addressed in our brief. First, I want to talk about the satisfaction argument, and Judges McBrayer and Stafford, I want to first talk about a couple of the questions you all ask appellants counsel. And one of those was, to sum it up, was, is this the position that Home Service Oil is taking on appeal, or are these the facts in the record that were the basis of the trial court's decision? And members of the court, there was an evidentiary hearing took place at the lower court level. A representative for Home Service Oil testified, and Mr. Baker testified. There was not a court reporter for that hearing, so in compliance with the appellate rules, we submitted a statement of facts. And if the court would look at pages 13 of that statement of facts, which was the page entered by the trial court, the facts clearly state, with respect to the satisfaction issue, that Mr. Baker testified that he received a copy of the October 2, 2014 petition to show cause against Mr. Evans, that he discussed that petition with Mr. Evans, and that they made the decision to pay $3,500 to Home Service Oil. Mr. Baker further testified that it was his understanding that that was in satisfaction of the judgment. It was also undisputed and the record.
So was there any documentation that was exchanged as part of that payment?
There's nothing in the record, Your Honor.
Did Mr.
that there
Evans
was.
testify at this evidentiary hearing?
He did not, Your Honor.
Okay, and so why didn't Mr. Baker just say, well, I'll offer the 35? I mean, he'd been in negotiations with him before, but he went through Mr. Evans instead?
Yes, Your Honor. That's the facts that are in the record.
Okay.
And so that payment was
why he did that, or is that a
um,
mystery too?
I think that's also a mystery, Your Honor. And that might be one of the issues with not having a court reporter in hearings.
And I guess another issue there is that if I'm paid to satisfaction of judgment, I would say prepare a notice of satisfaction of judgment so I can file that in Missouri and be done with this instead of having this litigation. But
Yes, Your Honor. And I believe, if Mr. Baker had sought legal counsel, hopefully that would have been the advice that he would have gotten in Missouri. I think, a couple things on that particular point. And this kind of goes to the reliance element that Home Service was briefed up on this appeal. And that is, in the subsequent, I think 5 years after this exchange, tripartite exchange between Mr. Baker, Mr. Evans, and Home Service there was no communication between the parties. And Home Service says, Mr. Baker, they tried to skip trace him, they couldn't find him. But at the end of the day, the evidence shows that consistent with Mr. Baker's position or his understanding of what happened, he thought this case was over and done until the attempt to enroll the judgment here in Tennessee.
so how did your client, I'm not sure I understand how your client relied to his detriment here on the number in the show cause motion.
Yes, Your
What detriment did he suffer?
Well, I think that the detriment is that he took no further action with respect to the amounts that were owed. So I think that, the reliance on the statement is, okay.
That doesn't seem like a detriment. That seems like a good thing.
Well, I think the detriment.
I'm putting that out of my mind. I'm not going to worry about that.
And I want to address it, Your Honor. I think the detriment is, the pre-judgment and post-judgment interest rate on the Missouri judgment is 18%. So I think the incentive of, the difference in incentives between doing nothing because there's nothing to be done and, oh boy, I got 18% accruing annually on a 5-digit judgment. I believe that the incentives are different there. And so, the interest accruing on at most what would be an $800 judgment after paying $3,500 on the $4,300 judgment, and the interest that accrues on the $15,000 judgment or balance, depending on what the case may be. I believe that's the detrimental reliance in this case. And it definitely impacted the way that Mr. Baker went about, dealing or not doing anything with respect.
I was going to say, not dealing with the judgment creditor.
Right, Your Honor. But I believe in this instance and under the law, taking no action with respect to something can be the same as taking actions depending on what your posture is. I don't think that the equitable estoppel doctrine can only apply to affirmative actions versus inaction that is motivated or as a direct result of someone else's conduct.
Mr. Clopo, let me ask you a question, and
Yes, sir.
I want you to address this in your rebuttal as well. I'm looking at the trial court's order on the statement of evidence here. It's filed September 9, 2021. I'm looking at the second paragraph, and I'm not sure how to interpret this because it says, the trial court determines that the accurate record is reflected in both the statement of the evidence filed by the appellant as modified by and corrected by the appellee's objections to the statement of the evidence. The court therefore orders and certifies the record to include both documents and submitted and as attached hereto verbatim. So I'm having difficulty figuring out what the statement of the evidence is. Obviously, appellant filed a statement of evidence. You filed some objections. Is that, are your objections to be considered as correct, or how do we look at that?
Yes, Your Honor. And Rule 24 is definitely a unique one and one that I have not had much experience with. But I think it's appellee's position that, the appellants, they submitted their statement of facts. We disagreed with those statement of facts. We submitted those to the trial judge in accordance with the rules. And in order to present a complete record of what the trial judge viewed, he submitted to his court both sets. And I think that if you look at the portion that the appellee submitted, we specifically point out, it's item 1 or item 3 from the appellant statements. We point out what those issues are and why we have issues with them. And the trial court, we believe in interpreting that order, kind of reading them together, that to be the trial court's view as well as what the evidence, showed as a result of the evidentiary hearing in this case.
Okay. All right.
And I want to spend a little bit of time, members of the court, talking about these two issues of the equitable estoppel elements that the appellants have brought on appeal. The first thing I'd like to say is it is absolutely inaccurate to say that Mr. Baker or the trial court rather did not rely on all of the elements set forth in Wern and in Cracker Barrel in making its decision in this case. Both Wern and Cracker Barrel were cited extensively and, almost, kind of being the authoritative position of the law in Tennessee with respect to equitable estoppel. Both of those were relied on in the trial court briefing in this case and the appellate court briefing. And it's appellee's position that, the factual findings the trial court made in this case, when reviewed at the abuse of discretion standard, which does apply, the parties don't dispute that it applies.
Wait, abuse of discretion on what? What's the abuse of discretion standard here? What's that applicable to?
Yes, Your Honor. And if the I don't believe this is a matter of dispute between the parties. And I think it's in page 39.
You put that in. I know you had put that in your brief, but I was trying to decide where the court was exercising discretion. It seems like to me this is all fact finding, and it would come to us with a presumption of correctness unless the evidence preponderates otherwise, but there wouldn't be any sort of abuse of discretion.
Yes, Your Honor. And I believe that a presumption of correctness would be the standard that would apply with respect to each individual factual element that is at issue in this case. And I believe that specifically the standard that applies is, did the trial court apply an incorrect legal standard? Did it reach an illogical conclusion? Or did it base its decision on a clearly erroneous assessment of the evidence, as Your Honor mentioned? And if none of those things are present, then there's not a basis for appeal with respect to enrolling in enforcement in post-judgment proceedings.
So you're saying enforcement is a discretionary decision?
Yes, Your Honor. That's the position of the appellee in this case, is that the extent, they're obviously full faith and credit to the existence of the judgment coming from another state, but the decision as to whether or not to the amount to enroll based on the facts in the record, which are viewed under the clearly erroneous standard, that is a discretionary decision, by the trial court here. Yes, Your Honor. And so I think that it's important to point out that a lot of the issues that the appellants raise with respect to both the actual knowledge or the lack of ability to know in this case, both of those arguments are, they kind of stem from the fact that there is a lack of evidence in the record as to, what the trial court found or didn't find with respect to these elements. Our position is we don't believe that's the case, and we believe that because of the lenient standard that applies in this case, that's not a problem for us on appeal. But in assuming arguendo that it is a problem, members of the court, I think that the case law in Tennessee is pretty clear. The correct thing for this court would be to issue a remand for additional factual findings by the court, rather than for this court to take those steps on its own and to make factual determinations as to whether or not there are issues with the trial court's opinion. Well, that would be a specific remand, of course. And barring that, members of the court, I believe that I've addressed most of what I've wanted to cover. Are there any further questions?
I see none, Mr. Clabo.
Thank you.
Very much. Mr. Dixon, you have your 3 minutes for rebuttal.
Yes, thank you, Your Honor. I'll try and be brief and touch on all the points requested. But first, Your Honor's asked why Mr. Baker went through Mr. Evans. I believe it's clear at this point why, and I've established his knowledge of at least $17,000 being due as of October 2nd, 2014, and his knowledge of that based on receiving the prior document less than a year earlier. So as we said in our brief, this is clearly an instance of Mr. Baker sticking his head in the sand, attempting to take advantage of a situation. And of course, there's no documents saying that his debt was paid in full between HSOC and Mr. Baker. And Mr. Baker, as the court noted, made no direct communication to HSOC pertaining to that $3,500 payment. I know we touched on, or Your Honor's touched on the statements of facts and the statements of evidence. Frankly, our position would be that the objections are without merit, but in this appeal, it really is of no consequence, because no matter how you look at this, all you have to look at really is the order and compare that to the case law that's well established. That showing that the trial court did not, in its order, set out any of the requisite elements for estoppel that must be found with respect to Mr. Baker. And I want to end with a quote from a 1902 case that's still cited today, a seminal case, and that case is Crabtree v. Bank. And it states, "For it is essential as a general rule to the application of the principle of estoppel that the party claiming to have been influenced by the conduct or declarations of another to his injury was himself not only destitute of knowledge of the state of the facts, but was also destitute of any convenient and available means of acquiring such knowledge. And that where the facts are known to both parties or both have the same means of ascertaining the truth, there can be no estoppel." Again, that's Crabtree v. Bank, 67 Southwest 797, 1902. To conclude, I want to just put on the record that the appellant asks this court reverse the trial court on the estoppel issue, find that the appellant is not estopped from seeking the full amount due under the judgment, and direct the trial court to enter an order to that effect. Alternatively, the appellant requests at minimum, given the court's order, that the court remand the proceedings to the trial court with direction that it consider each of the requisite elements of estoppel as set forth in the Tennessee precedent cited by appellants in their brief and today. If there are no other questions, I will rest. And I thank you for your time.
Thank you very much. Thanks to both of you. Ms. Dempsey, would you adjourn court?
This Honorable Court of Appeals